All right, we're live. I am attorney Vincent Davis, and this is The Secret: How to Fight CPS and Win. Today, we're going to be talking about a couple things. I told you last night that I'd be talking about the detention hearing today, your very first hearing in juvenile court. And also, I'm going to be making an offer to you guys. I just published another book, and it's called Civil Rights Litigation: Suing CPS Social Workers. It's a victim slash survivor's guide to winning your case and breaking free of the CPS system. All right, that book I think came out just recently, but I have some digital copies that I'm willing to share with people. And the one way to get the digital copy is to contact Grace. Grace at vincentwdavis.com. Grace, just to let you know, I sent you a version of the digital copy of the book probably about 15 minutes ago. So you have a copy in your email, and people that contact you, go ahead and give them a copy. The book is about 150 pages, and it's going to be hopefully on Amazon soon, but I'm just, giving out the book, and we might even be charging the person who helped me publish it wanted me to charge at least for it. But today, anybody that contacts Grace at vincentwdavis.com, Grace, I'm telling you to send them a copy of the book for free. Okay? All right. Now, before I get into the detention hearing stuff, oh yeah, Grace has already put that in the chat, her email for you to email her for a copy of my new free book, Civil Rights Litigation: Suing CPS Social Workers. Okay, so today, as promised, we're going to be talking about the initial hearing in a CPS case. In California, they call that the detention hearing. Okay, and it's governed by code and by California rules of court and by case law. And let me tell you what happens at the detention hearing, or what should happen at the detention hearing. At the detention hearing, if you're a parent who doesn't have a private lawyer, um, in California at least, and I think in most states, because it's an important constitutional right, you'll be appointed an attorney. Okay. That attorney being appointed to you the same day sometimes causes problems because there may not be enough time for you to confer with your attorney to have a meaningful detention hearing. One of the things that's happening now, I've noticed, is that these court-appointed attorneys are contacting you the day before the hearing. And if you're contacted the day before the hearing, you do have some time to prepare, make some notes, and hopefully talk to the attorney about how you're going to defend against the detention hearing. Now, I'm going to assume that this is a detention hearing. In 99% of the cases, the social worker has already detained your child away from you, or is looking for a court order to detain the child if the social worker wasn't able to find you to detain your child. Now, the minute that you have an issue with a social worker detaining your children, it's my advice to find a lawyer to call to confer with or consult with. You are about to enter the most important lawsuit of your life, and it's regarding the detention and possible loss of your parental rights of your children. I get a lot of calls from people, and they believe that the detention hearing isn't that serious. But I'm here to tell you that it is very serious, and it's your first step down the CPS path. In California, in most places, the 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 judge who hears the detention hearing also is assigned to your case for all practical purposes. Good morning, Cassandra. How are you?
Good morning. How are you?
Thanks for joining. I'm talking about the detention hearing.
Okay.
So it's important for you to start off well in that court and in that case. And here's the strategy that I try to implement. If you're not going to get the child released to you at the detention hearing, you want to at least put forth evidence that starts to make the judge think about your case. The burden of proof for the social worker to get your children detained at that very first hearing is low. Okay. And it's low by law. Now, do I agree with that? No, I'm just the messenger. Should it be higher? In my opinion, yes, but it's very low. And the only thing the social worker has to prove is that you're a risk to the child. And here's the problem. At the detention hearing, the social worker's reports are admitted into evidence by law. The judge must consider them. And I get a lot of people that tell me the social worker reports and the petition are just simply not true and substantive or major ways. But in order for you to prove that, you're going to have what's called a contested disposition hearing. So let's go back for a second. You're at the hearing, you've been assigned an attorney the day before or the day of the detention hearing, and that's generally 48 to 72 hours since your children were taken. Now, it's longer in some places because of COVID. There are special COVID rules. And I think in California, I think it got up to like a week. They could wait a week before having the detention hearing, which, strangely enough, might be an advantage to you so that you can properly prepare with an attorney for that very first hearing. So when you get to court and you see the petition, there are going to be allegations against you. And in California, the petition are allegations that you are a risk to the child or that you have abused the child. And you're going to see in that petition all types of things that you haven't thought about, some that you haven't even thought about for years. I get a lot of calls, and here's the situation. Mom loses the kids because mom was arrested for drunk driving, and dad, who doesn't even live with mom, they bring up an arrest that happened, 10 years ago. Nothing really connected with why the children were detained, but they're throwing everything in the kitchen sink against you. So you need to prepare for that. So the first thing that I would do is I would go through the petition and I would go through what they call the detention report and any addendums or last minute information reports prepared by the social worker that the judge is going to look at that day. And remember, these reports are automatically admitted into evidence, even though they contain hearsay and multiple hearsay. In law school, we used to call that totem pole hearsay. Hearsay on top of hearsay on top of hearsay on top of hearsay. This seems ridiculous in a judicial setting, but that multiple hearsay is allowed by law. So if you have a problem with that, don't blame the messenger. Talk about voting and changing the laws, getting propositions together, organizing. But you're facing your first detention hearing. So I'm just explaining what the rules are, not that they're right or wrong, or that you agree or disagree with them, explaining the rules so that you know how to best help your lawyer represent yourself at this hearing. Okay? So the first thing you should do is you should go through the report and you should make detailed notes about what is true, what's not true, what witnesses, what really happened, that type of thing. And you and your attorney should consider whether you want a contested disposition hearing. In California, one of the things that you can do is you can have the hearing, and if you lose, you can ask for a contested disposition hearing. Typically, in my opinion, the way the law is written, that just allows you to cross-examine the social worker. But most judges allow you to present affirmative evidence to show that the social worker is not telling the truth or the social worker has made a mistake. And so you should be considering that as you go through this report. It's important that you go through this report and you make written notes, because if you just, tell your attorney, all right, the attorney doesn't have a photographic mind. He or she may not remember everything. You may forget to tell your attorney everything that you thought of when you were reading the detention report. So don't leave it to conversation. And it's best to email this kind of stuff. There's a documented digital file of what was sent and what was said. So that's how in my opinion, you should be communicating with your attorney. Should you talk to your attorney? Of course, you should be talking to your attorney. But if you want to transmit any important information, like paragraph 4, line 3, the part where the social worker said you hit the kid or you sexually abused the child, it's not correct because, number one, I was incarcerated at the time. Or number two, I was at work at the time. I couldn't have done that. Number three, you know, Aunt James and my friend Mac, they were there. They saw that I didn't hit or do anything to the child. So those people all become important witnesses, and you can start to develop your defense by going through the report, saying what's wrong, coming up with witnesses and other documentary evidence or pictures or videos to prove that something's not true or correct. Now remember, this is not a trial. All right. Unfortunately, you have to wait to the jurisdictional phase of the case, which is your next hearing, to bring forth witnesses to prove that everything is false or true. Right. So, however, you can start off with representations, documentary evidence, and perhaps the judge will allow you to present a witness at a contested disposition hearing. So the burdens are very low, and there is a statute that says that the court is supposed to accept what the social worker writes in the report at this very first hearing as being true, right? What a ridiculous rule, but that's the law. So we're not here to change the law, and us talking about it to the judge about being ridiculous is a waste of time. That's the law. What are you going to do to prove otherwise, to show the social worker's not being truthful, or to show the social worker has misquoted a witness or misquoted what the child said? Remember, the social worker in 99.9% of the cases wasn't present when this alleged abuse happened. She wasn't there when, mom and dad got into verbal argument after the party. She doesn't know if they were drunk or not. She wasn't there when, allegedly dad sexually abused stepdaughter. She wasn't there to watch mom, get high using meth or, cocaine or whatever. She wasn't there. So the social worker is only reporting what people have told her. Now, do people ever lie? Yeah. Yeah, they do. Do people ever exaggerate what has going on? Yes, they do. I recently had someone call me, and they live in Los Angeles, and they live in an apartment. But if you look out their apartment, their window is approximately 5 or 6 feet away from their neighbor's window. A completely different apartment building. And the neighbor has a habit of calling CPS on these people whenever the neighbor hears something that she doesn't like. Cursing, yelling, allegedly, calling kids names, listening to the kids scream and yell about different things. Every time a kid yells or screams doesn't mean they're being abused. They may not be getting their way and being a little spoiled about something, and then the neighbor thinks it's child abuse and calls CPS. And then where are you? Cops come over, a social worker comes over. So all of these things you have to remember in preparing for your detention hearing. Generally, in some counties, it's not like this in LA County. The social worker shows up for the detention hearing, and if you want to cross-examine the worker right then and there, that can be done. In Los Angeles, so you generally the emergency response worker who writes the detention report is not in court, so they usually continue it. And I think the law provides you to have what's called a contested detention hearing. They used to call it a Dennis H. hearing after a case in California, an appellate case, within 3 days or 3 court days, something like that. Now, here's that's the good news. The bad news is the judge could decide that instead of giving you this contested hearing, to set your case for trial, what's called a no time waiver trial, within, I don't know if it's 10 or 15 court days. And then you bring all of your witnesses. But remember, at this first hearing, you want to make a good impression, even if you lose, because you want to start putting in the judge's mind some doubts about the social worker story. It's important because the social workers are going to be writing the eventual, what they call jurisdictional and dispositional report. So it's going to be important that you get your story out there, at least, the major points at that very first hearing. Because judges are smart people. Okay. I don't care if you like your judge or you don't like your judge. They didn't get put in that position because, you know, they're stupid. They're smart people. And they remember, just like you. They're just like any other person. And they'll remember you and they'll remember some of your facts. Was one of the things I've noticed over the years is that a lot of judges take notes. You don't know this, but they take notes and they stick it in the file. Next time the hearing comes up, they pull out the file, they pull out their notes. Oh, yeah, I remember that case. And I look at and the judge looks at their notes, and that's what, they kind of have refresh their recollection about what they thought and what they were feeling about your case. Okay, so don't think that your judge won't remember. He or she will remember more times than not. Okay, so that's generally how I approach detention hearings. It's a broad framework because every case is different. Some people, are accused of domestic violence. Some people are accused of emotional abuse, physical abuse, sexual abuse, drug abuse. The list goes on. Not taking care of the kid's medical condition, not sending the child to school. It can go on and on. So every case has to be looked at kind of differently and very specifically, but the importance is going through that detention report, making your notes, giving your attorney evidence, documents and witnesses that can testify on your behalf. Remember, the attorney wasn't there. He or she is in a worse position than the social worker. Social worker allegedly has talked to witnesses, has talked to people in the family, the parents, the child, the relatives, the next door neighbor. The attorney, he or she hasn't talked to anybody. So they're in the worst position to assist you, and that's why you have to help them. Don't rely on the attorney interviewing you, right? 5 minutes before the hearing. You provide that attorney, you take the offense and provide that attorney the information by way of email and also talking to your attorney. But always have a record that you've talked to your attorney and you've provided him or her this information. I assure you, all attorneys, private, court appointed, they will all appreciate this because it will make their job easier. Okay? Now, one of the things that you should know that you do not have to continue your case after the detention hearing 4 to 6 weeks, which happens in a lot of hearings. You are entitled to what's called a no-time waiver of trial. So in some cases, if I argue the detention hearing and the judge doesn't release the child, or at least place the child with relatives, I set the case for a no-time waiver of trial so that we can get to this and decide this right away. A lot of times, your trial won't be for 6 to 8 weeks, sometimes more, after the detention hearing. And you need to make sure that your case is pressing forward if that's going to be to your benefit. Now, it may not be your benefit. There are some cases where you don't want to have a trial right away. Let me give you an example. Let's say that the social worker has alleged that you are a drug addict or an alcoholic. Okay? One of the things that you can do to win your case is to have a period of time where you've taken drug testing or alcohol testing for 4 to 6 weeks, 10 weeks out. And then when you have all those negative tests, you go into court and say, hey, judge, under the law, you're supposed to decide the case as of today. Am I a risk to my child because I'm a drug addict? And if you have 10 clean tests, 15 clean tests, the answer is no, you're not, right? And then in the disposition hearing, you have to prove that you are a clear and convincing evidence that you're a substantial danger to the child. If you've got those clean tests, the social worker can't prove that. in my humble opinion. But you can only take those tests if you take the time between the detention hearing and your trial, right? You need time to test. You need time to prove to the judge that those allegations that you're a drug addict and can't take care of your child are false. And the best way to do it in juvenile court is the test, the negative test. So sometimes you don't want to set the case for trial right away. Okay? So I hope that gives you an overall framework. Each case is different, and the burdens and the evidence are different. The law is different at that first hearing. Now, when you go to the second hearing, the law changes. There's different statutes, different rules, different evidentiary burdens. Okay, different legal tests. You know, you have more ability to bring forth witnesses and evidence to prove what the social worker is saying is not true. So don't just think that, the detention hearing is a throwaway hearing. I get that from a lot of people, and they tell me, oh, I heard that, at the detention hearing, we're not going to get the kids back. So it's not really a big hearing that we should be concerned about. And that's not true, because here are other things that can happen at the detention hearing. Number one, if your child was taken and placed in foster care, that's the time to ask the judge to place the child with relatives or friends of the family. At that very first hearing, sometimes the relatives are out of state. Your Honor, I ask the court to order an ICPC to consider the children being placed with my, grandfather in Nevada. Here's one of the things that you should do and consider doing at every hearing, even the first hearing, is bring those relatives and friends with you to court so that and the judge knows, that there are people out there that care about where this child is, what's happening to this child, and that these people vote. Okay, one of the most extreme examples that I've ever been involved with, I represented a man in Lancaster, in Los Angeles County, in the Lancaster court. He and his wife had been accused of killing one of their children. Serious case. At every hearing, there were probably 150 to 200 people who came to support that family. And they were in the hall sitting down. I'll never forget the very first hearing. We got called into chambers, and not allegedly, he was there. One of the main sheriffs of the building said that he wanted all of those people to leave the premises because they were a security risk. The odd thing was, these were all people from church, from one of the local churches. So, how are they going to be a security risk? Anyway, the attorney, a very famous attorney who represented the mom, I had the dad, said, look, this is a public building. These people can be here to have support. And the judge didn't get involved. Said if the people want to be here, they can be there. And if they were going to cause a security problem, you would have cause to evict them. But they haven't done anything but crowd the court, crowd the hallways. And at every hearing, they had that many people there to support them. And guess what? As the case turned out, it turned out in favor of the parents. Now, did the people there every day at every hearing have an effect? I think so. But you can talk about that with your attorney. All right, so that covers the detention hearing. Cassandra, do you have any questions for me?
It's early. No, I don't have any questions, but I do have a comment. Like when you were saying that they do the totem
Totem pole hearsay.
Yeah, totem pole hearsay, like, that's so what happened to me. It was like, so I know what you're talking about. That was, like, way out. They brought up things from, like, way when I was a juvenile even. Like,
Right.
it was way out, and I didn't even think that they would use my juvenile stuff between me and my mom on the case for me and my kids, and they did. It
They
was
always will.
yeah.
They have access to that information. They're the government. They know everything about you. And if they can use it against you, it will be thrown in and used against you. And it's one of those things where it may not even be relevant, but it's the kind of thing is like the judge hears it, and subconsciously, it may persuade the judge, oh, Cassandra's not a good mother.
Yeah, they would try to use the fact that me and my mom had problems when I was a juvenile, and that's why I needed to do family counseling because I might project it onto my children of
Yeah,
how she yeah.
and the interesting thing is might doesn't satisfy the law. They actually have to have evidence, but unless you say that to the judge or bring that up, your attorney brings it up, the judge is going to listen to it and may or may not use that in their decision making. I was in a court a few months ago, and we were at the very first hearing, and the judge ordered my client to do drug testing. Not only drug testing, hair follicle testing. Now, the way the case law is written, if I don't say anything, that becomes the law of the case. And I objected. When I first objected, I said, Your Honor, I object. Hair follicle testing is unconstitutional in California. You're not allowed to order that. And everyone in the courtroom kind of like looked at me like, oh my God, I can't believe he said that. Because, a lot of the people in the other attorneys and, people on the case, they knew that was the law, but it was just the practice in that courtroom. Everybody gets to take a hair follicle test. And if you don't object to it, that becomes the law of the case.
Mhm.
But then the second thing that we started talking about, I told the judge, I said, I object to you even ordering any kind of drug testing at this stage of the case. Because the way I read the case law is you can't order drug testing until you take jurisdiction over the kids. And that happens at the jurisdictional hearing. We're at the detention hearing. You don't have the authority to make that order. And, of course, everybody was shocked that I would say something like that. But you got to make those arguments for your clients. And I go to a lot of hearings and I just watch cases and they order drug testing, boom, 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 like it's, like the sun rises in the east and sets in the west. It's just the way of the world.
Yeah. They ordered a drug test at my detention hearing,
Yeah.
and
No,
then it went
but
all bad from there.
did your attorney object to it?
She didn't really object to anything. She just told me I had to do everything they said.
Well, and that's a strategy. That's a strategy that some people use. And I'm not saying it's a bad strategy in every case. But if you don't know as an attorney whether your client is going to test positive for drugs, or your client is going to test positive for drugs, why would you agree to that? It's kind of like a societal thing. Well, you don't deserve your kids unless you test clean anyway. I don't care what the law says, and I don't care what stage of the case you're at. That's kind of the attitude I get a lot of times. And, a lot of people don't like me when I say, objection, the court doesn't have jurisdiction or doesn't have the power to order drug testing at this point in time. Now, the fact that because you didn't know, but it doesn't matter, ignorance is no excuse, right? That's what the law is. That's what the rule is. You didn't object, your attorney didn't object. So guess what? You got to go take a drug test. And guess what? If it comes out bad, that's going to follow you for the rest of the case. And it could have been easily avoided. But you didn't know to say, Your Honor, I object. You don't have jurisdiction to do that yet. Now, at some point in the case, the judge does have the jurisdiction. but not at the detention hearing. In the old days, I used to make arguments, and this is what some smart judges would do. They would say, "Okay, Mr. Davis, how about this? I'll release the kids to your client, but your client has to agree to drug test." And of course, sometimes the client would drug test and test positive. Sometimes they drug test and they test clean. But it gave that assurance to a judge. If you're a judge and you're responsible for these kids, you want to have assurances, and you have to play to your audience, right? Because I've witnessed over time some judges, making decisions and going with the parent, and it turned out it was a nightmare. I remember one case that was kind of famous in LA County where a judge released some kids to a mother against the social worker's recommendation. And the mother, I think, jumped off the roof of a building in downtown Los Angeles with all the kids. And I think they had like 3 or 4 dead children. Guess what happened to that judge? Right? I mean, they drug him through the mud. All kind of hearings in Sacramento about how could he do this? Why did he do this? So, judges aren't off the hook. And if you're a judge and you don't know this person, are you going to take a chance? Your career, your reputation? I don't know. Those are just things that run through my mind if I were sitting as a judge. Like, can I really trust Cassandra? A lot of people think that there's a lot of corruption. Okay. And I know Miss G is, a fan of this theory. And it's good that she's not here today. But so I'll say that it's not corruption at all. It's, hey, I'm the judge. I'm responsible for these kids. You're not making me feel good about releasing the kids to you. And in the old days, not since COVID, but maybe online, you'd be sitting right there in front of the judge. And the judge will look at you. And I've never talked to anyone about this, but I'm sure if I were sitting there, I'd look at you and I'm going to think to myself, I wonder if I can trust Cassandra with these kids. Judges have to make decisions like that every day. So if you get judges making a lot of conservative decisions, now you know why. Right? It wasn't corruption. It was they had a serious concern that wasn't alleviated. Now, is that the law? In a lot of cases, probably not. But just like that judge with the 3 dead children, if he had to make that decision over again, would he make the same decision? I don't know. Right? So that, think about those things. So when you go to court, think about, you got to give the judge a good feeling that you're going to take care of your kids. Forget the law. Everybody thinks it's just the law. No. The judge was wearing a black robe, and we've given that judge a lot of power and discretion in these cases. Figure out how you're going to win your case. People call me all the time, oh, the judge didn't do this, the judge didn't do that. And I'm always thinking, well, what did you do to show the judge that you should have your kids? Nothing. I should win because CPS didn't follow the law. Okay, that's not a good strategy. It's a strategy. It's not a good strategy. And I tell this to Miss G all the time. Look, the time to complain about corruption and wrongdoing social workers or lying social workers will come. But let's get the kids back first. That's the number one goal. Get the kids back or get them with, a friendly relative. But get them someplace that they know. because it's a hell of a thing for you to be, a little kid. You're taken from your mom and you just end up at somebody's house that you don't know. And I've heard many stories. It's not always a good thing. When we really think about it, maybe we should have just left the kids with the parent, you know, because what they're now going through in foster care is worse, right? You don't know what's happening at that stranger's house. You don't know. Sometimes it's good stuff. Sometimes it's really bad stuff. So at that detention hearing, make sure that your attorney makes the argument, let's get these kids with relatives. There's a statute, a law in California. It's Welfare and Institutions Code section 309. It requires the social worker to do an investigation to place children with relatives and family friends. They call them nephrons. All right. And it actually puts the burden on the social worker to do the investigation. A lot of social workers come to court and say, oh, the mother and father didn't tell me any relatives that could take the kids. In a lot of cases, they never even asked the mother or father. But it's just like they believe that if the father or the mother doesn't bring it up, oh, well, we're going to keep them in foster care. And that's actually not the law. The law is that the social worker has to affirmatively go out and search for relatives. Now, one of the ways to do that is to ask the parents, hey, tell me your relatives. The kids' aunts, uncles, adult siblings, grandparents. Tell me about those. And they actually have to go search for these people. Years ago, the city and county of San Francisco lost a big lawsuit on this very issue. And they're the only county, and I've represented people in a lot of counties, they're the only county that do this. They actually hire an outside service on every case that researches the background of all parents. And they produce a computerized report to the judge. Like, here are all the relatives that we could find. We called them and they said they wanted the kid or they didn't want the kid. The interesting thing is, one of the things I found out up there is that sometimes when they call and they don't want to release the child to a relative, they call you and say, hey, you're grandma and grandpa, right? Yes. Well, just want to let you know the kid has been taken into CPS custody. And we were thinking, you might want to keep the kids, but I don't think it's a really good idea because it's expensive, or you have to provide medical insurance, or you have to keep the kid with you 24 hours a day, 7 days a week, or, or, they do things to convince you not to take the child. So they get to keep the child in foster care, even though they did the report on all relatives. I bet if you interviewed parents on their case and asked them while their kids are in foster care, strange foster care, how many of your relatives were interviewed for possible placement? When it's all that can be found, very few are. Very few are. Now, there are some social workers that are big time pro relatives. Okay, so I'm not saying that it happens in every case, but it happens in a lot of cases. Happens in a lot of cases where I'm called. First thing I ask people, I say, where are your kids? Well, what do you mean? I say, well, who are they living with? Foster parents. These are people that have cases open for months. I said, well, aren't there any relatives that might be able to take the kids? I don't know. Or, yeah. Or, yeah, we told the social worker about it, and the social worker said no. Although it's not the social worker's decision, right? Social worker said no, so we just dropped it. We forgot about it. At the detention hearing, you got to have the judge order. In the old days, they don't do this anymore, but in the old days at the detention hearing, there was a judge that I used to practice in front of when I was a court-appointed attorney who would ask on every case. He had developed a form where you had to write down all the relatives. It was like a 3-part carbon form. And they used to use that in a lot of courtrooms in LA County. I don't know if they use that anymore. But he wanted to know who the relatives were because he was getting sick and tired of, social worker not finding out who the relatives were, or some relative coming up, 2 years into the case saying, "Hey, I want the kid." And his first thing was, "Well, where you been?" "Well, I didn't know." Well, the way to solve that was to have the relatives interviewed at the very beginning of the case, which they're supposed to be, which that's supposed to happen anyway under Section 309. So if you have a case in California and your kids aren't with relatives or family friends, read WIC 309. Just Google WIC 309 and read it. You're going to be astounded what it says. Okay? All right, Cassandra, if you don't have any questions for me, I want to thank you for joining. Oh, one of the things that I didn't, Cassandra, you didn't hear, and I want to repeat it for the audience. For a limited time, if you contact Grace at vincentwdavis.com and request my new book, she will send you a free digital copy. Okay? And let me give you the official title of the book. It's Civil Rights Litigation Suing CPS Social Workers. It's about 150 pages. It was much longer than I wanted it to be, but it's a victim survivor's guide to winning your civil rights case and breaking free of the CPS system. Okay, so go ahead and email Grace, and for a limited time, we're going to be giving those away free. Later, it's going to be on Amazon for like 10 or $12. All right. Okay, Cassandra, thank you for joining me. I know Miss G is going to be joining me tomorrow at 9 a.m. for our show. And tomorrow at 9 a.m., I hope we have a guest. We had a guest lined up today, but we couldn't contact her. We have a guest lined up for tomorrow. And I will also be talking about the second hearing you go to, the jurisdictional / dispositional hearing in a juvenile dependency case. And I'll be giving some pointers and some pro tips about how to win that case or that hearing. Okay? So have a
Okay.
good Saturday, and we'll see you guys tomorrow.
I have one thing.
Oh, I almost pressed the end broadcast button. Go ahead.
Deidre, I will answer your question on my show on Tuesdays at 4:00.
Oh,
So
you
you
were
don't got
talking.
to.
Oh, Deidre Payne. Let's
Yeah.
see what Deidre's saying. Good morning, Mr. Davis. Do you happen to see my question from last night, right before we ended? I'm sorry, Deidre, I didn't see that. Let's see, what are you saying now? My opening brief due date for my appeals case is October 17th. Okay, that's Monday. If my appellate attorney hasn't contacted me yet, does that mean the attorney most likely doesn't think there's anything worth appealing? No, it doesn't mean that at all. It could mean that, but it doesn't mean that automatically. What I would suggest, Deidre, you do is you today email your appellate attorney and find out, what's going on. A lot of times I've heard court-appointed appellate attorneys do the brief and they don't talk to you. And I mean, I've heard that so much. I'm not surprised that you're saying that to me. If I was doing your appeal, I would have contacted you and talked about the case because there are some issues on appeals that you just can't find out from reviewing the court reporter's transcript and the clerk's transcript. But like I said earlier, every attorney does cases differently. That's why it's called the practice of law. Everybody has different practices. All right. All right. So I hope, well, we're on streaming to 8 different platforms and there's a whole bunch of questions.
Yeah, her question was for me, but I told her I'd
Um,
tell her on my show at 4:00 on Tuesday.
okay.
It's a long question. Well, it's a
All
long
right,
story.
folks. All right, folks. Thank you for watching, and we'll see you tomorrow at 9 a.m. Bye-bye.